Please be seated. This is the time scheduled for oral argument in Barkhurst v. Kingsman of Route 66, our case number Civil 130166. Both sides have been allocated 20 minutes for oral argument. If the appellant desires to reserve any time for rebuttal, you can do so, but the time and the clock on the podium is what the time you have, including your rebuttal time. So if it says 2 minutes or left, that includes your rebuttal time. To advise the parties, you should be aware that we have read the briefs, we've looked at pertinent portions of the record, we have conferenced this case, so we're relatively familiar with the issues and the facts. Additionally, we are audio and video recording this argument, so when you step up to the podium, please clearly state your name and who you're representing. With that, counsel for the appellant.
Good morning. May it please the court. My name is Brad Book. I represent appellant Trenton Barkhurst. There are 6 reasons that I can think of under existing Arizona law why the Kingsmen of Route 66 should be held to owe a duty to patrons at the Andy Divine Days Rodeo Dance to protect them from an unreasonable risk of harm. I'd like to spend just a minute talking about existing law before going on to those reasons. Beginning with at least the Ontiveros case in 1983, the general rule has been that every person is under a duty to avoid creating situations that pose an unreasonable risk of harm to others. Then what Ontiveros said was, specifically in the context of alcohol, the duty to protect others is broader, it's greater, it's more extensive, because we're aware of the dangers of alcohol. Then in 1994, the Hernandez case extended the Ontiveros concept by saying that even parties that are not licensed to serve alcohol, in fact, even parties that do not actually serve alcohol, still have a duty to avoid creating a risk of harm to others, again, out of recognition for the dangers of alcohol, particularly when underage people are involved. Hernandez, I think, really drives home the public policy point, the public policy concern, and endorses the concept of broad legal remedies when it comes to alcohol-related matters. Then Gibson, in 2007, tries to clear up the duty issue by saying that duty is not about foreseeability, the historical view, if you will, but rather duty is about public policy. And Gibson says that the relationships between the parties can be a part of that public policy consideration, but that they are not determinative of the issue of duty. In fact, you could sort of see relationships fading as a factor even in 1995 in, I think it's the Rudolph case, where this court held that there can exist a duty even when there is literally no relationship between the parties. Rudolph held that the sponsor of an event can have a duty to design and conduct an event to prevent persons in the vicinity of the event from being injured. So against that historical context, that historical legal context, if you will, and under Gibson, as a matter of public policy.
Sir, let me go back on Rudolph. Rudolph has an important fact that we don't have in this case, which is that the sponsor had a duty of care because the government had a government permit that required it to assure that all participants operate their boats safely. So it was required by the government to take on this responsibility.
Yes.
As part of the permit. We don't have anything that I'm aware of in this case involving something similar, do we?
We do not.
Okay.
We do not.
Right.
And I think that what Gibson would say is that is a factor. It is not a dispositive factor, but a factor look at. And again, looking at the totality of the matter, 6 things that I think create a duty in the Kingsmen to protect patrons at the Andy Divine Days rodeo dance from the risk of harm. Number 1, the Kingsman sponsors and conducts the entire week-long Andy Divine Days festivities in Kingman.
What does that mean?
Yeah.
It means that they are the organizers, the advertisers, the promoters, and the conductors.
What do you mean by conduct? I mean, when it comes to the rodeo, for example, they organize it, sponsor it, produce it, what about this?
That's the rodeo.
invite the
This is a bar,
participants.
okay?
Talk about the best butt
Yeah.
contest. Okay. What did they do to conduct the best butt contest and the selling of alcohol at the best butt contest?
This has been quite a day for those of you who've been first argument.
I was hoping this would be a little simpler than the last.
Right, yeah.
Your Honor, I'll answer your question, but I want to be clear. I think that Gibson says you don't focus on that level of detail in determining duty, that is a breach of the standard of care or a causation issue at that level of factual analysis.
But you were saying that, I'm getting back to your own argument, which is they sponsored and conducted this event. And I'm asking the best bar, and I'm asking how did they conduct the best, so as to create a duty. I don't care about the standard of care about whether they were negligent in doing it at this point, because the only thing the issue before us is duty. I just want to know how did they conduct that event?
Understood. And I want to be clear that my point to the court is that the Kingsmen of Route 66 organized the week-long Andy Divine Days events.
Okay.
Now,
Did they go
within
to the
that,
dam bar, for example, and say, please do this? Or did they say, please participate and let us know what you're going to do?
the answer to that is yes, and it's a question of fact. The answer is that they took sponsorship dollars from the dam bar. They used those sponsorship dollars to conduct the entirety of the Andy Divine Days week-long events. They took the dam bar's banner and hung it up at the rodeo. They identified the dam bar on their website that advertises and promotes, and they invited the public to come to the rodeo dance at the dam bar.
But that's more, to me, more promotion of events, as opposed to conducting the event, the dance.
At the dance itself, at the dam bar, focusing only on that one little aspect of things, they, having once invited people to come to this event through the things we've discussed already, their people are present. It's a question of in their Kingsmen of Route 66 garb. Their rodeo clown, their rodeo announcer works at this event. Their rodeo clown entertains at this event. Their members are judges for the men's and the women's and their auxiliary for the women's or the best butt contest. So is the label conducting the right label? I'm not sure if that's exactly the right label, but are they
That's the label you used.
participants?
That's the label you use.
Well, it was the label that I used to describe conducting Andy Divine Days, the week-long event.
Okay.
You know, I'm not familiar with, I'm familiar with the record here, but let me give you an example. I'm familiar with what goes on in Prescott. Prescott has Frontier Days in July, and the city is very involved in sponsoring those Frontier Days. But they don't run a separate event in the Palace, in the bar, the old bar downtown. The Palace does whatever they do. But the Palace, there's ads and banners and everything that the city puts up. Now, is the city responsible? Does the city have a duty to someone who may well be overserved by the Palace, a separate entity? But the city is out there sponsoring Prescott Frontier Days. They've done it for 100 years or thereabouts.
I'm not familiar with
That's
with Frontier
basically what
Days.
happened here, isn't it?
I don't think so. I don't think so. And maybe if I could list the reasons why, I could try to answer your question. Point one, reason number one, if you will, from our perspective, is that the Kingsmen have certainly sponsored, advertised, and promoted the entirety of the event, including specifically the event at which this injury occurs. Number two, they are putting this event on for the economic benefit of their members. The purpose of Andy Divine Days is to drive tourists and tourist dollars into Kingman businesses.
But what's the event here? What's the event? Is the event everything that goes on in the entire city of Kingman? So the library have library tours, so they're responsible for the library tours?
During that week, there is a laundry list of events that are specifically conducted as a part of the Andy Divine Days event, and those things are listed on the...
Let's take Judge Norris's example. Let's assume as part of that is a library tour of our historic library. And someone takes the tour and trips because there's a book left on the floor, there's water left on the floor. Does that, your argument is, okay, that means that the Kingsmen can be liable because they sponsored the umbrella event and this person was injured, and therefore they had a duty to make sure that the library was safe for the tour.
I do not think that would be my argument.
Why not?
Because under Ontiveros and Hernandez, alcohol is not involved. And these people knew very well, from having conducted this event for 25 years, that this is not a church social.
So it's alcohol's another factor.
It is another factor that I think Gibson says we have to look at the picture. We have to make a public policy decision based upon all of the circumstances that the picture show us. But point number two is that this is something that is done for the economic benefit of the membership of this organization. Because they are the persons who own and operate the businesses that benefit from it. Number three, and I touched on this before, they collect sponsorship dollars from the bar where the rodeo dance is held. And they use those sponsorship dollars on the entire Andy Divine Days event that they're putting on. And in exchange for those sponsorship dollars, they hang the banner of the bar and at the rodeo grounds and so forth. Number four, they actually advertise and promote the specific rodeo dance event on their website. The Kingmen of Route 66 have a website that advertises all of the events, and it gives a schedule of where and when and so forth.
What's your best case on this fourth point that says advertising and promoting in this context creates a duty?
There are two things. Number one, I think it's an express invitation. Number two, I think it is I liken it to placard liability in the trucking context. Where if you are driving a tractor-trailer rig under the banner of XYZ company, that imposes liability on XYZ company. because it is holding out to the public that it is, in fact, the operator of the tractor-trailer.
So you're saying this is a principal agent, the respondeat
Well,
superior?
in my own mind, I think of it more as an apparent authority matter.
So what's your best case that says someone's promoting and advertising a dance that someone else is going to conduct, but they're promoting and advertising it, and that makes them the principal for that apparent agent?
Yes, I am advertising and promoting and expressly inviting people to attend an event and thereby representing to you that that is a reasonably safe event to attend.
I'll ask the question again because I'm probably not being clear. What's your best case authority for saying that creates a duty?
I'm sorry. I think the Rudolph case implicitly creates that authority.
Do you want to get to your fifth point?
Fifth point, I guess I've covered it. The fifth point really is the express invitation to come to this event. Last point is that it's the content of that invitation. The website is inviting people to this event. And as I said, knowing full well this is not a church social. They know that this is an indoor, outdoor, inside the bar and out in the parking lot, Saturday night live band, beer drinking, yeehaw, country dancing event with the Andy Divine Days rodeo announcer calling the action and the rodeo clown in between and the best butt contest and the like. There is more than ample reason to know that this is not the library.
Well, does the record reflect that there are other establishments doing similar things at the same time so that, anyone who comes to the rodeo gets to have a wonderful time, whether that they're Den Bar or
There's
anyplace
nothing
else?
in the record about that.
Was there any claim made, I didn't see one, but that this was a negligent selection theory? In other words, we had some duty to make sure that the entities that participated in the rodeo days were responsible, and we were negligent in doing that.
Not articulated as a separate or independent theory, but we discovered facts concerning that and intended to present that at trial.
Did you move to amend did you move to amend the complaint to assert that?
Potentially, I suppose.
Did you?
Oh, no, I'm
Oh,
sorry.
okay.
In any event, I respectfully submit to the court that it is all of these circumstances taken together, where alcohol is sold and flows freely, where a special permit even beyond a regular liquor license is required in order to conduct this thing out in the parking lot, to do it outside. All of these things are what Gibson says: look at all of the circumstances, evaluate the public policy consideration, take a look at the risks created by alcohol, consider Ontiveros, consider Hernandez, and then see if all of these circumstances do in fact create a risk of harm. I say they do. I say further, they create an unreasonable risk of harm such that if there is not adequate security personnel who are there checking IDs and providing some kind of physical crowd control, that the risk of harm is an unreasonable risk of harm. And I would respectfully suggest that the collective public policy concerns requires that the parties who play a role in putting on this kind of event and inviting the public to attend this kind of event have a legal duty to protect patrons from risks of harm that are attendant to the event.
I guess the concern I have is I don't see how then any community or any community group could put on, sponsor any event where other individuals also have their peripheral activities without then being liable, because I don't see any end to the liability. I really don't, and that's what I'm struggling with.
I think that's exactly what the Gibson case says.
Well, I
that
don't
we-
think
that
Gibson
we-
goes that far. Gibson did not adopt Justice Hurwitz's concurrence that there should be a duty of care at all times on all people.
I
It
understand the
just didn't go that
difference.
far.
I understand the difference. But what Gibson says is that you look at the circumstances of the specific event. And I think the library example is a good one. That's a good place to draw a line.
But isn't that going beyond what Gibson says we can do in looking at duty? That's getting into the interstices of the facts, and we're supposed to be looking at duty from a higher elevation?
In part, perhaps, but the facts it drive the duty to the extent that one needs to understand the context in which the event occurs in order to decide whether a duty should exist. And you know, at the end of the day, isn't insurance the answer to the city? I mean, this isn't a city, but to whatever risk may exist. Thank you. Appreciate it.
Thank you.
May it please the court, Judge Kessler, Judge Norris, Judge Portley. My name is Joe Brownlee, and I represent the Kingsmen of Route 66. As Judge Norris pointed out, almost every community in the state of Arizona has a festival of some kind. The Ostrich Festival is coming up this weekend in Chandler. The Kingsmen are a civic group of businessmen, CPAs, bank owners, car dealers, construction developers, and so forth. They also have a group of women called the Cowgirls of Kingman. They're similar to the Kiwanis, the Rotary, the Lions Club, and just about every other civic organization you can think of. Now, the appellant asks you to hold the Kingsman responsible for his client getting beat up in a bar fight that I'll discuss in a little bit more, merely for sponsoring an event. That's it. Merely sponsoring. There's nothing else. Or to extend Arizona dram shop law to cover sponsorship. That is certainly not the case at all.
Mr. Brownlee, does the record contain, at least I couldn't find it, but you know it better than I do. Does the record contain any information that would illuminate whether the Kingsman exercises any type of filtering as to what events they were advertised? So if I own a house and I want to have a party open to the public in Kingman, and I say, Kingsman, I'd like to advertise my event on your website for Frontier Days. Do they exercise, does the record show us anything, that they exercise any type of not supervision, but any type of, yes, you may, no, you may not? Or do they just advertise anyone who comes to their door?
I think you make a donation, they'll put you on their website.
Is that right?
Well, it's more than a donation. It's a
Okay.
sponsorship.
Okay.
On the fourth week of September of every year for the last 30 years, they have held a professional rodeo cowboy association rodeo for 2 days, Saturday and Sunday. If you purchase a sponsorship, which I think the record says was like $700,
Okay.
then you get listed in the website. You get to put your banner up if you have a banner at the rodeo, and
So I pay to play,
you pay to play.
Okay.
Yes, ma'am.
but if I don't pay, I don't play.
That's correct.
Okay.
The whole point of Rodeo Week is to get the community involved. The more, the better. And as they say on the website, which the appellant told you about, we invite you to enjoy all the fun and entertainment brought to you, Kingman, during Western Week, including the dances, plural, parade, chili feed, and of course the rodeo. There are dances all over Kingman during Rodeo Week. Specifically on Saturday night's a big one. Now, let me talk about the dam bar. It's got a name that makes you think of rootin' tootin', almost,
Tombstone.
could be Tucson, could also be Blazing Saddles.
That
The-
came to our mind.
That came to your
We
mind,
thought
yes.
about that.
And they do have a chili feed, which also brings the campfire scene into focus. But that's another story.
That's not the scene we were thinking of, but
That's
that's okay.
okay. The Dan Bar is a family steakhouse. It's huge. And it's one of the places that the Lions Club, the Rotary, and the Kingsmen meet monthly, the Chamber of Commerce. It is a family-oriented place. Does have a bar. No kids allowed. It has a bar, separate bar, but it has a huge indoor and outdoor steakhouse. Once a year, they get a special permit. Hello, special permit from the city of Kingman to fence in the parking lot and to hold a rodeo dance in that parking lot.
Dan Bar gets the permit. special
Dan Bar
permit.
gets it,
Right.
not the Kingmans. Dan Bar gets it. They rope off the parking lot. They have a band, and let's talk about the best butt contest. Okay, this is not a wet T-shirt contest at spring break. This is
Do we need to go into the details of
No.
the argument?
15, 20 seconds of
And we don't need
men get up and they do a little dance with the band.
move along.
Then the women get up and the kids.
So we do that.
So this is a family event, okay?
So it's-
Now, if you Google best butt contest, you get 570,000 best butt contests in the world.
Have you done that?
I did that,
Oh, okay.
yes. So this is not a one and only best butt contest. It just happens to be at the
Okay.
Dan Bar.
Okay, so why
Okay.
doesn't Kingman have a duty?
Have a duty because, A, this best butt contest had nothing to do with them. It was 2.5 hours before the bar fight. None of the individuals in the bar fight were involved in the best butt contest. It's a red herring. It sounds nasty, titillating, so let's stick it in. It doesn't matter that a Kingsman or two may have volunteered to be a judge,
Yeah,
okay?
okay.
The record is clear. The testimony of the president of the Kingsmen, they had no official duties on Saturday night. They were all involved from daybreak.
It was a small.
At the rodeo.
It's a small city. I mean, in essence, the fact that somebody may be wearing a Kingsman T-shirt or a shirt and as an officer shows up and helps judge doesn't mean they're controlling it. There's no evidence that that person was there to help control and supervise things. Is that your point?
That's correct. And I don't believe there were any officers there. As a matter of fact, the president said he had a barbecue at his house that night for the officers.
If the plaintiff had been injured at the rodeo that the Kingsman sponsors and puts on, or at the rodeo dance that the Kingsman that weekend, not dance at the restaurant, but the dance that your client puts on, we'd be presented with a different. You have a separate dance, right? I thought that
Oh,
would-
the Kingsman dance is
Have their
on
dance.
Friday night.
Friday night, yeah. If the plaintiff had been injured at the Friday night dance that the Kingsman puts on, or at the rodeo, would you agree that we'd be presented with a very different situation here?
Absolutely.
Okay.
We wouldn't be here. The Kingsmen would be responsible.
Right, okay.
And at our dance on Friday night, we serve alcohol. We have
And I
security,
understand.
private security, and all that. It's totally different.
I've read a number of the cases cited by the appellant in their briefing that concern other events, and they're mostly out of state, and as yours as well. Let me have you play devil's advocate. What facts here would we need to have in this record to show there might be liability to your clients for an event that an entity like them that doesn't sponsor but advertises and promotes? Are there some facts that you think are red flags for liability that in comparison are not presented here?
Certainly.
Okay.
And I think Judge Gertler, the trial judge, made that interpretation, made that decision, and determined the facts based upon what he thought was controlling law, the sponsor case of Rudolph versus Arizona Bass Federation. In the Rudolph case, First, the members voted on where they were going to have the fishing contest. There was no vote by the Kingsmen on holding a dance at the dam bar. Number two, the Bass Federation obtained a special permit. That didn't happen. The permit was by the by the dam bar, and the dam bar, the testimony is uncontroverted. The dam bar organized, controlled, and conducted the 2009 dam bar rodeo dance. Number three, the permit required the safety of the public. Here, there's no permit. There's no duty by any government authority saying you're responsible for the safety of the public at the dam bar dance. In Rudolph, they organized and designed the bass tournament. There's no organization, there's no record whatsoever that the Kingsmen did anything to organize, design the dance at the dam bar. The Bass Foundation designated the area of the bass tournament. The Kingsmen had nothing to do with deciding where in the parking lot or if in the park lot at all the rodeo dance at the dam bar is going to be. The Kingsmen did not establish any rules. In Rudolph, they established the rules of the tournament. And specifically, they were responsible for security in the Rudolph case. There's nothing to suggest that the Kingsmen had anything to do with security. The dam bar, in fact, got the permit, organized, planned, ordered the liquor, controlled the liquor, displayed the liquor, served the liquor, hired security, instructed security, and supervised security. Kingsmen had nothing to do with that. Regarding there's one big exception to sponsorship, and that brings in the Markowitz case and the Hernandez case. When you look at those, you wonder, how in the world did the Arizona Park Board become responsible for a diving accident in Lake Havasu City? They leased the land.
That's also true of Hernandez.
And that's also true of Hernandez. That's how the Board of Regents got involved.
Plus, they hired someone, the Board of Regents, or appointed someone to go to the fraternity and make sure there wasn't underage drinking.
Correct. The record is clear. The Kingsman has no ownership in the dam bar. It has nothing to do with the property whatsoever. For some reason, sponsorship and liquor and responsibility has been a hot burning issue in the Northeast. Those cases that we cited are not precedent by any means, but they're instructive to show how other courts have dealt with them. In the Vogel versus West Mountain case, which was a ski slalom tournament that Miller provided free beer. The injured person tried to get Miller to pay for their injuries. The court said, and this was a New York case, absent control of the event, free beer does not make you liable for an injured skier's problem. In O'Sullivan versus Hemisphere, again, a Miller case, Miller decided to donate beer for a promotions lunch. Somebody got injured. The court in Massachusetts said, you didn't control the premises, you didn't control the beer, so a sponsor is not responsible. The Previs versus Spano case, which is a Connecticut case, involved a pool party where somebody got injured, and Pfizer had sponsored this event. Again, the court said, without the right of possession of the facility or to control the event, a mere sponsor is not liable.
What if a drug company decides to hold a promotion, let's say at a resort in Arizona, and they invite all these doctors and serve liquor, and the resort serves liquor. They pay for the liquor. The resort serves the liquor. And then one of the doctors is driving home and kills somebody. Do they have any response? They didn't serve the liquor. They just sponsored the event. It was a promotion to serve, for their drug company. Is there any liability? Is there any duty of them to control that?
If I don't know if you mentioned a drug company, but let's say it's
Are you a drug company?
Merck.
Because I had a case like that.
Okay. If a
was
drug
practicing
company has a seminar or something, and there's liquor served,
But they don't serve the liquor.
oh, they don't serve the liquor.
Don't serve the liquor. They're just sponsoring the seminar, and they're saying to doctors, come on in, have a good time, attend the seminar, learn about our product, and by the way, there's lots of liquor here.
Free liquor?
Free liquor.
Well, they're doctors, of course it's free.
Free liquor. It's a drug company. Of course, it's at that point. Of course, it was free liquor.
At that point, the drug company would be responsible. Yes, because they control the event, they possess the facility by renting it from the resort.
Okay.
Yes, they would be responsible.
So,
And they were providing the liquor.
right, so the key factor, from your perspective, is control or lack thereof. And then perhaps a secondary factor of equal importance is whether the sponsor has ownership or control of the property as well.
Correct.
Okay.
Correct.
So control of the event, perhaps control of the actual situs of and the property, kind of hearkening back to invitee liability and the like.
There's a similar case. It doesn't involve alcohol, but the Petrello versus Big Daddy's Racing case out of Connecticut, where an association held an expo, and people are holding expos all the time, and you get to rent a booth, and that's your booth that you can show what you do as far as, I guess, racing. And somebody tripped over some booth poles. They tried to hold the association responsible, and the Connecticut court said, no, the sponsor didn't control the booth. The booth proprietor did, and they're not responsible for the injury. There was no possession or control over the booth.
That was Don Garlett's.
Pardon?
Don Garlett's Big Daddy hot racing primo.
Yes. In the Mary versus Becker case, another Connecticut case, a person was injured at a picnic and wanted to hold the sponsor of the picnic responsible. They were responsible because in that case, they rented the picnic ground. Kingman didn't rent anything at the dam bar.
That's Hernandez.
That's Hernandez, correct. So the appellate wants you to expand dram shop liability to be just over a sponsor based upon the fact that there might be some underage liquor going on, consumption going
Be
on.
more common law liability. There's not an appeal here on a dram shop claim under this. It's really just saying, let's take the concepts of dram shop liability and say a non-sponsor, a non-server of the alcohol can be held liable,
Well,
right? That's what they're trying to say.
no, a sponsor, even
A sponsor,
more
but
vague
a
than,
sponsor who doesn't serve the liquor.
and isn't even present. Okay. Dram shop, as we know, has been extended to social guests, but you have to control the premises
Social host, yeah.
or control the substance, and that's where Gibson is. Gibson was a drug case. Casey gave Gibson's decedent 8 oxy. There's a direct connection between the prohibited criminal act
Right.
and
Well, that was another factor the court looked at, was the
Sure.
criminal act.
That was an easy case, frankly, because they had a criminal statute. They left us with the hard cases.
And in this case, the appellant's own dram shop expert said there is no dram shop liability whatsoever on the Kingsman. So the question is, should this court expand dram shop liability for mere sponsors? And if you do that, look at what you're doing. More than likely, depending upon what happens in the next 2 days, there's going to be a Super Bowl in Arizona in 2015. The Super Bowl has many, 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 many events.
I will, tell you.
Oh, I don't mind sticking the NFL.
Yeah,
They've got
Just
money.
because
the
they,
answer, of course, to that is, I think, is that if there's possible liability or possible duty, the sponsor of the event is going to make real sure that anybody who's participating in the event under their sponsorship is going to indemnify them and have the bond to do it.
that's true. But then take something perhaps less involved and involving less billions of dollars. St. Patrick's Day is coming up. All sorts of places have St. Patrick's Day. Are we going to hold the Arizona Italian Irish Club responsible for anybody who gets beat up in a bar fight? No. Pat Tillman's race is a big race in Tempe. If somebody gets beat up in a bar fight,
So you would be saying, let's say the run, the Phoenix run, let's say it's Payways.
rock and
Payways
roll.
a rock and roll.
yes,
If
PF
someone serves liquor at that event, someone starts
or
drinking. liquor
after that event.
After that event, they would be liable.
Yeah, they have their own event, but over here are all these other events that are riding coattails.
Okay.
Is that marathon responsible for anybody who gets beat up in a bar fight? It'd be a dangerous precedent. It would have a chilling effect on civic organizations, on public events, and I believe it was Hernandez that said, really the legislature should take care of this, not the courts. If they want to expand it to sponsors, let them go crazy.
I'm not sure you want to say that in this.
Spend time.
So in conclusion, under the facts, the statutes, the case law, and public policy, the Kingsmen did nothing that would allow them to be liable for Mr. Barkhurst, who got beat up in a bar fight.
But for, pardon the pun, the sponsorship.
But for sponsorship, and case law is clear, that does not equal liability. Thank you. We'd ask you to uphold Judge Gertler and to affirm.
I have 3 sentences. If I say
Counsel, first, we're recording it.
Oh, I'm
You
sorry.
got 12 seconds.
I apologize. Number 1, Gibson, Rudolph, Markowitz, Hernandez, and Ontiveros all say that the right of control is not dispositive of foreseeability. It's not a factor in foreseeability. Number 2, the Kingsman of Route 66 is not a mere sponsor of these events. It is the conductor itself, in fact, of many of the events, and it is the advertiser, promoter, inviter to many of the others. And so mere sponsorship does not accurately describe this circumstance in which we ask a duty to
What's
be
the third
imposed.
sentence?
I'm sorry?
You have 3 sentences. Did you do it?
I think so.
Okay. Thank you.
Not great sentences.
Okay, that's it.
May I make one comment? This has been a very interesting case, and there are some unique aspects of it. But we recognize that your client was seriously injured in this fight, and I want you to make sure that we do take that very seriously, and we do not mean to be in any way disrespectful, because we do understand that.
And, bar fight is not described.
Yeah, I just want to make sure that you understood that. Okay.
Thank you very much. I'll
Thank-
pass that along.
We will thank both counsel for their arguments. We will take this matter under advisement, issue a written decision in due course. We stand at recess to allow the attorneys in the third oral argument to approach the bench.